All right, so we're here with John Loevy with his own law firm. What's it, Loevy and Loevy?
Yes, Loevy and Loevy.
Great. So we're very honored to have you as our special guest. And John, could you just talk a little bit about how you became involved in the Innocence Movement?
Sure. Well, I went to law school and I graduated, went to work for a big firm downtown. And I only worked there for a brief period of time before starting this firm. We're dedicated to civil rights. We do all kinds of police misconduct, police brutality, police shootings, and wrongful conviction cases. And in the course of doing this kind of work, we've really become educated about the problem of wrongful convictions. And more we've started doing post-conviction work and habeas petition kind of things where we try to exonerate people that have been wrongfully convicted. So our practice has sort of evolved towards litigating these kind of cases. There are plenty of lawyers who make their living and work full-time on trying to exonerate people who've been wrongfully convicted.
And why did you become involved in the movement?
Well, we are a civil rights firm, and therefore me and the other people here are interested in devoting our energy, talents, and skills to things that matter to us and things that hopefully achieve justice. And there's plenty of ways to use your law degree, and I think this is a good way to use your law degree, is to advocate on behalf of someone who is in prison for a crime they didn't commit. Not only do we do the innocent stuff, to be clear, we're also a litigation firm, so we also litigate cases, much like a personal injury firm or a plaintiff's firm, for people that, having exonerated themselves, go forward and argue that the police caused their injuries by misconduct. So we bring jury trials and cases where we try to get compensation and justice for them as well, from that end too.
Yeah. And do you work with law students at all?
We do. We started the exoneration project at the University of Chicago. So every semester we have a clinic where we teach over there, and the members of my firm generally rotate through there because sometimes lawyers like to teach, and sometimes they get their fill, and sometimes they want to scratch that itch, so they teach students who at the University of Chicago decide to do this kind of stuff. And so we use the students to do various parts of the process. A big part of it is the intake and investigation, but sometimes they're involved in the litigation too.
And do you think that makes a difference in the way that they're learning about the law and the criminal justice system?
Absolutely. If there are law students in the audience or people considering becoming one, clinical education is a good way to get your feet wet and to really learn about the law. Because, if you think about it, you go to law school, they teach you about the law, and it can be kind of dry and academic. But when you have an opportunity to really litigate cases on behalf of people where you feel passionate about it, that's what really gets people excited about the law. And the fact is, there's a lot of litigation where you wouldn't really be able to litigate because, like, if it's a corporate dispute and there's a lot of money involved or it's a business dispute, they're not going to let law students do things. When you think about wrongfully convicted people, there are so many people needing help, and the demand is being so inadequately met that law students can be entrusted to work on, obviously, objectively very important cases right in school because there's not enough people to handle that stuff. For people looking to get participate in a very important case, it's a really good opportunity.
We have a question from the audience. Diane, go ahead and hit the talk button and ask your question.
Diane, are you there?
Diane, are you there?
Melvin. Glenn, can I just pause for a second?
Yeah.
Yes.
Please tell them I got talk at 2:30. I have 30 seconds. Yeah. Sorry about that. I did not hear Diane.
No, we didn't either. So we'll just press ahead and maybe she'll be able to chime in a minute.
Okay.
So what are some of the issues that you've seen in the cases that you've handled that you think are the most prevalent causes for wrongful conviction?
Well, just taking sort of a half step back, there's a lot more wrongful convictions than people want to believe and that people used to believe. I think for a long time, the courts, the judges, the prosecutors, the public believed that if a guy got all the way to trial and then the trial evidence came out and the jury convicted, that there was a real good chance, if not a certainty, that the person who was convicted beyond reasonable doubt was in fact guilty. What's really changed that, obviously, is in the science of DNA. Because we now know that some of these cases that look like airtight cases where, all the witnesses were pointing to the same guy, the guy confessed, everything would suggest he was guilty, all of a sudden, the DNA proves he wasn't guilty. So then everybody has to say, what was going on there? How could 10 eyewitnesses have all got it wrong? How could he have confessed to something if he didn't do it? But the DNA has definitively proven in a certain number of cases that's exactly what happened. So DNA obviously doesn't apply to all cases. There's plenty of cases for which there's no DNA, no possibility of exoneration by DNA. But if you extrapolate the statistics on people getting exonerated based on DNA and the kinds of problems that showed up in those cases, kinds of problems I talked about, false confession, bad witness identification, jailhouse snitches, making up nonsense, bad science. In the cases where you can prove that the convictions are bad through DNA, you extrapolate those to the big pool, you realize that those kind of problems are actually more prevalent than anybody really cares to admit.
Diane is ready to try again.
All right.
Yes, as somebody who's been the subject of the high-level prosecution for the last 6 years, I guess the biggest concern with respect to wrongful conviction is the role that defense attorneys play in the process. And the rules by which the court gives deference to attorneys versus defendants. For instance, the rule with respect to discovery in Illinois being given to the defense attorney versus the defendant. I mean, in the end, how are you supposed to know that your counsel has been ineffective if you're never allowed to see the discovery and know what information the attorney had when representing you?
That's a good question. I am not impugning defense attorneys, because many of them work hard under incredibly difficult conditions, because a lot of them have, especially the public defenders, have a ton of cases, and it's hard to vigorously and aggressively represent all of them. But sometimes they do fall short, and they do a bad job. And some of these cases where the DNA exonerates, and you go back and you read the transcript, you're like, what was the defense attorney doing? You didn't put on a defense, and you really could have done a lot more than you did. Specific to your question, Diane, for the people that don't understand the Brady obligation that you were referring to, the way our justice system works, you have an obligation, if you're the prosecutor in the state, to turn over not just the stuff that's bad for the criminal defendant, but they have to turn over the stuff that's also good for the criminal defendant. That's called exculpatory information. The case was obviously Brady in Maryland in the 60s. The Supreme Court said if you're accused of a crime, you got a right to that. Now, Diane points out it doesn't do any good if they give it to your lawyer sits on it and doesn't share it with you and then does a bad job. But I would be surprised if your lawyer, a defense lawyer, could withhold that from the client. A lot of times the clients are not sophisticated or, they're not lawyers, so they don't have much need for the stuff. But there's plenty of people who are accused of crimes who are extremely smart and who do better than their lawyers about poring over the police reports. Oftentimes they're more motivated to find problems with the evidence. So I think the answer to your question is, if a person who's accused of a crime says to his lawyer, whether paid or appointed, I would like to see the evidence that the state has turned over, that the defense attorney would have an obligation to share that with the client, and then the client would have access to it. So I don't think they could refuse such a request.
Well, unfortunately, having gone through about 5 private attorneys, yes, they do refuse a request. They either give limited access to the information or, review it superficially and so forth, but a lot of it you never see unless you go pro se. And there are a lot of people, I think, in Illinois courts going pro se due to financial need at this point. And, they don't have the resources, really, particularly if they're sitting in county jails or in IDOC, to draw up motions and get access to the legal resources they need to do research on their cases. So they're really at a loss.
Yeah.
Good
Yeah.
point. You know,
I don't know why Illinois is so restrictive with respect to the prevention of discovery versus other states. Other states seem to be a lot more lenient in this respect.
Well, I do disagree with the premise of your question that a defense attorney has a right to prevent you from seeing it if you're accused of a crime. There may be restrictions on what they will allow into an institution, a jail, but at a minimum, you should be able to meet with the defense attorney and demand that he shows it to you. So maybe just in your personal situation, I don't think those guys or those attorneys are doing right by you, and I think we should assist or possibly involve the court. You have a right to see it. Ryan, did you have other questions?
Yeah.
Well,
Yeah.
the other thing I wanted to bring up with respect to
So,
defense,
John, I was just wondering if you could talk a little bit about how the innocence work that you've done has affected you personally, either in the way that you practice law or in your personal life.
Well, a lot of people become lawyers because injustice bothers them, and I think of myself in that category. And maybe before I started doing this work, I believed that people who were convicted of crimes and that went to trial and all the evidence came out, they were guilty. And now that I realize that mistakes are made with more frequency than many of us would like to acknowledge, that obviously has shaken my faith in the justice system, and it's given me sort of, passion to fight against the injustice and to try to make other people aware that the system really is fallible. The police, there's plenty of good police officers, plenty of good detectives that are very smart and very ethical and are doing their best. There's some that are sort of cutting corners and aren't as good at it as we would hope. And same with the prosecutors. Sometimes prosecutors decide that they just want to get a conviction to rack up their stats, and they lose sight of the fact that it's really about trying to do justice. So the net result is sometimes people are wrongfully convicted. That bothers me, and it has affected me personally. The world and its institutions and our society and this great country of ours has imperfect institutions, and it's up to us to fight back against it and try to make it work as well as we can. So I view this work as consistent with that.
Yeah, yeah. So a lot of what you do then is, fight these cases individually. Can you think of reforms that maybe we could press for that would help to change the system so that we don't just have to fight each case one by one?
That's a good question, and obviously it's already begun. People will talk about wrongful confessions, or coerced confessions, people confessing to crimes they didn't commit. Many of you in the audience might not believe that happens, or if it happens, that it's a very rare and remote thing. It's not. People get pressured. They spend days and days being interrogated under coercive conditions, and sometimes they're not that smart or sophisticated or educated, and sometimes they're pressured, hey, if you accept a small role, we'll let you out, and there's psychological warfare being practiced on them, and they may confess to something thinking that that's their only or best way out, and then boom, they're hit with accountability, and they're looking at 100 years. So to counter that, to answer your question directly, there have been reforms where the entire interrogation has to be videotaped. And that way, there's no dispute about what happened during the interrogation. Then people don't have to come to court and argue about, oh, there was coercion, I wasn't fed, I was interrogated for 12 straight hours, I was yelled at, I was physically abused, I was threatened, I was tricked. If the entire interrogation is videotaped, then obviously people's rights are protected, and the police and the prosecutors, their side of the case is protected as well. So there's a clean record about what happened and less chance for abuse. So that is an example of a legislative solution where laws get passed requiring police departments to videotape interrogations. And the police in Chicago at first, or in other places, it's only used for like murders, but they resisted it at first, but I think they're starting to come around that it reduces the accusations of misconduct. Nobody can accuse you if it's all right there on videotape. Interrogation is not supposed to necessarily be a trick where you're just trying to get a confession regardless of guilt or innocence. And I think that some Some detectives treat it that way. They don't care if you go through innocent. They're just going to war with the guy in the room, and if they can get him to confess, they win. And if that means feeding him the details that he wouldn't have otherwise known, and then psychologically putting pressure on him to accept them or to trick him, then that's good enough for them. But if it's all videotaped, then you can see if the details came from the guy who was being interrogated or if they came from the detective. Maybe a second set of legislative reforms that's extremely important is on the eyewitness identification stuff. For a long time, people had more faith in eyewitness identification than they should. And for 200 years, our justice system was based on the principle that if people stood up in court and pointed their finger and said, that guy did it, that carried a lot of weight with jurors. And the social science has since caught up with the reality. And the social science, in other words, psychologists and others have tested this in an academic setting. And they have determined that people aren't nearly as good at making eyewitness identification as they thought they were, as we thought they were. People's confidence is unduly high. They're frequently wrong, think they're right. If you tell them that if you give them positive reinforcement, they misremember how certain they were at the time they made the identification. And by the time they get to trial, they're positive they got it right, and they no longer even understand that they may have been manipulated or that their memory may have evolved. There's been even relatively recently, this big article in the New Yorker about how memory is a funny thing. You know, people don't really understand how memory works. It's not a video camera where you can play it back in your head. Your memory has sort of evolved over time, unfortunately, to a degree that some of us don't appreciate and understand, and we have to work hard to understand that. So what that, all of that means is that eyewitness identifications are less reliable than people believe they are, jurors believe they are, and that there should be a lot more caution. So there's been a lot of legislative solutions proposed, some enacted, to protect against bad eyewitness identification. For example, lineups, they should be conducted by someone who's called a double blind. But sometimes when the police officer knows who the suspect is, that influences the lineup. Whether the police officer means that maliciously or innocently or benignly, they unconsciously can steer people toward their suspect. For example, if the suspect's in the middle, the person looks at number 2 and says, well, I don't know, maybe it could be that guy. The guy just, and the person who's doing the lineup just stands there. We say, number 5, that person's got similar hair. Number 3 says, number 3 looks sort of familiar. And then the person doing the lineup says, oh, really? Tell me more about that. And over the course of that process, the witness, without even realizing they're being manipulated, and possibly administering the lineup without even realizing that they're being suggested, can point to the suspect. So there are a number of protections that are being enacted into law, such as the double blind, such as sequential lineups, such as videotaping the process, that provide protection. So it's being taken extremely seriously, and that's a really good thing, because eyewitness identification is one of the biggest, misidentification is one of the biggest causes of complications.
Yeah, good. Do we have a question?
Yeah, we have a question from William Hogg. If you want to turn your mic on, William, using the talk button.
Are you able to hear me?
We can. Go ahead. Okay, I think it dropped you, John.
Right, can I hear?
William?
Did we lose William?
Yeah, I think so. If you want to go ahead and type your question, we can take your question that way. Annie, are you ready with your question if you press the talk button? Okay, well, we have a written question from Jacqueline. Can diversity on police force or prosecutors' offices be legislated by the state?
Can diversity be legislated?
Yes, can diversity on the police force or prosecutor's office be legislated by the state?
That's the question I'm not sure I know the answer to. I know that political pressure can result in diversity. If the prosecutors are elected, and or at least in some jurisdictions they're elected, and they do the hiring. And I believe that most prosecutors' offices and police departments place a premium on diversity, whereas maybe that wasn't true in the past. That they're increasingly trying to get law enforcement and prosecutor offices that look like the community. And some of them do a better job of it than others, obviously. But I don't know that legislators can pass a bill saying you have to have a quota. You have to have 15% minority, because I think that would have constitutional problems. But I do think that if people vote and get involved, political pressure can help ensure that these officers would better reflect the community.
Okay, question from William. Does the prosecutor have to provide evidence that is under HIPAA? Prosecutor refused.
Well, I mean, Brady v. Hanlon says that if it's exculpatory, they have to share it. Now, they can put conditions on how it's shared. And for those of you that don't know, HIPAA is that law that protects medical privacy issues. So there is some confidentiality if certain evidence, say like medical records of the victim, for example. If medical records of the victim are part of the case, then those can't just end up in public filings or in the newspaper. So those will be protected by HIPAA. But the defendant, it seems to me, has a right to that. The way it's handled in court is that it's provided under a protective order, which puts conditions on the distribution of the evidence. So the attorney gets it, and it's the attorney's responsibility to make sure that it stays confidential and private. But it does not seem like HIPAA would be a grounds to deprive the defendant of exculpatory information. Often it feels like the deck is stacked, that the judges sort of favor the prosecutors. I mean, I think that's a real problem. But I don't think they can use that as the barrier.
John, I want to go back to what you were talking about earlier in terms of getting legislation passed and issues of diversity and how important public pressure is for those activities. Are there ways that you think that we can better get the word out? I mean, obviously this course is one way to try to inform the public and motivate them to get behind some of these initiatives to try to help reform the criminal justice system.
Well, we do seem to be an interesting inflection point with Ferguson and stuff in New York having focused public attention on it, at least for the moment. So, I think we are at a moment in time in our history where people are listening to the criticisms of the criminal justice system and what many people believe to be some inequities, in particular racial inequities. So the louder people talk and care and protest, the more the system has to take notice of that. Voting is an important part of it. You'd be surprised how few people show up for jury selection. When you get a summons in the mail here in Chicago, in the Northern District of Illinois, a lot of times our juries are entirely white. And that's a reflection of who shows up to be on the jury. Because I know that the courts are making widespread efforts to make sure that these summonses are sent to everybody. And in fact, since it's been a problem with the jury being not having enough minorities, they've actually tried extra hard to make sure that the jury pool is expanded to make sure the pool includes all the different various racial groups and possible diversity. But people have a personal responsibility if they get the summons to show up and to have their voice counted. So it's on the smallest level: jury selection, showing up for jury duty, voting, and those are some of the things that individual people can do.
Yeah. Another trend recently has been the development of prosecutorial integrity units. And I was just wondering if you had any experience with those or any opinion about if that could possibly make a difference.
Well, obviously the prosecutor's officers who we frequently criticize because, in my view, all too often they hold back the convictions long after they should say, you know what, the fact the evidence and the equity suggest that this person should not be in prison and a mistake was made. It's the rare prosecutor's office that can say, we made a mistake. This guy was convicted beyond reasonable doubt by our office, but he's not guilty. You would be shocked how hard the prosecutors fight, even in the face of overwhelming evidence of innocence. And, if there's no other takeaway, it should be that, of what I'm saying, is that the prosecutor's office is, partly complicit in the problem because they won't ever admit they made a mistake. Not only that, people would probably be surprised to hear, but they fight against things like DNA testing. So if I brought a motion in a case saying, look, my client's been saying for 20 years he's innocent, and now science is advanced and there's some physical evidence in the case, we'd like to test it at our own expense to prove that we believe an injustice has happened and to not only exonerate someone who spent all too long in prison, but to make sure that the true perpetrator is punished because someone got away with this crime for 20 years. Let's just test the physical evidence at our expense and see what the physical evidence shows. We're not asking to let anybody out of jail. We're saying just let us test the physical evidence. An enormous number of prosecutors' offices, especially here in Chicago where I practice, say no. They fight it. They file motions saying to the court, don't let them test the physical evidence. Convictions have to be final. We can't have everybody bringing stuff like this up. So they are very invested in the premise that mistakes are not made and that their system is infallible. But in fact, the opposite is true. So doubling back to your question, I guess I'm almost out of time here, but your question about conviction integrity errors is a very positive development. It shows that regardless of why their hand is being forced, that some prosecutors' offices are trying to do the right thing by investigating cases where injustices may have happened. And I applaud efforts to put resources to that endeavor to find out if convictions should be revisited, because that's only a good thing.
Great. Do you have any important message that you want to send or stories that you want to share before you go?
I think I feel like I've communicated the message. If anybody has any specific questions, I don't have a problem answering them. My email, should I just tell my email address, Glenn?
Sure.
My email address is John, Jon, at Loevy, Loevy, I guess it's right there, it is on the blackboard.com. Our law firm is called Loevy & Loevy. You can find us on the internet. I'd be happy to, if people have further questions, I'd be happy to try to answer. All right?
Yeah, John, thank you so much for joining us. Really appreciate the work that you're doing.
Okay, thank you. Bye.
Bye. And now we're joined by John Hanlon, who is the legal and executive director of the Illinois Innocence Project, and Larry Golden, who's the founding director of the Illinois Innocence Project, to also be here to answer your questions and talk a little bit about the work that we're doing. You've seen both John Hanlon and Larry Golden on the videos for the course, but I'm sure that they have more to say. So the first thing I would say is, can we talk just a little bit about the exoneration from, was it last week or 2 weeks ago?
It was already 2 weeks ago,
All right.
which is hard to believe. And I don't know what level of information folks have, but so I'll assume just a little. About 10 days ago, a 48-year-old man named Christopher Abernathy was in court on that Wednesday morning, was exonerated in court after the Cook County prosecutors acknowledged that he had been wrongfully convicted and moved to dismiss all charges and, of course, vacate his sentence and for his immediate release. Later that afternoon, we went to Stateville Prison in Joliet on a cold day and stood outside as Lauren Caseberg, who was the primary lawyer on behalf of the project for Mr. Abernathy, as Lauren and his family brought him outside the prison. It was an amazing day for Mr. Abernathy and his family and for all of us who have put in time on this case. What's also very interesting about this is the press conference of the state's attorney after court that morning, in which she acknowledged that the primary piece of evidence that had been used to convict this man 30 years ago, which was a statement attributed to him, was not reliable, did not contain any meaningful details of the offense, and that Mr. Abernathy was, in her words, of diminished mental capacity, such that the statement was just simply not reliable. And she promised to launch a cold case investigation, having acknowledged Mr. Abernathy's innocence and cooperated in his release.
And this was a case of DNA evidence, so that there were items that could be tested. Can you talk a little bit about that process and the role of the grant money in that?
Certainly. This is a DNA victory. We have had 2 grants to do DNA testing. The biggest problem with a lot of the testing thus far is that the evidence on some occasions is not able to be found, but much more often is found but is very degraded, and in some cases contaminated. Heat is the enemy of DNA, and a lot of times what we find is that the evidence has been stored in such a way that it is degraded due to the storage conditions. But in this case, which is really amazing because this case is 30 years old, in this case there were numerous items of evidence that were able to be found, and we contacted the state's attorney's office in Cook County last year, not quite a year ago, but almost, and asked them to agree to do DNA testing that we would pay for and take responsibility for in terms of getting the evidence there, et cetera. And so ultimately, 8 items of evidence, most of them intimate, either swabs or items of clothing, were tested at the lab that the Illinois State Police asks us to use. All 8 of those items not only excluded Mr. Abernathy, but just as important, pointed with redundant profiles, pointed to a single other person. We don't know who that person is because the type of testing that had to be done on this evidence, again, because it was at least partially degraded, does not have a database. And so direct comparisons only were made. But the direct comparisons with Mr. Abernathy completely excluded him. And I will say this, without the grant money, Mr. Abernathy would still be in prison. And this case would not be an exoneration. And there are cases like that all over the country. DNA is a wonderful tool for convicting guilty people and for exonerating innocent people.
Thank you. And Larry, could you talk a little bit about now the process? I mean, Chris is out. We have other exonerees that once they come out of prison face now a whole new set of challenges. And the videos for next week, week 5, are going to talk about that some, but maybe you just share some of the experiences that we've had with some of our exonerees.
Yeah, actually, I thank you for asking that question because I did want to comment about that. I'm not a lawyer, so for me, my work in the project is at this point more supportive, if you will, of what is going on as the cases evolve through the legal process. I mean, I'm involved in the sense that there's consultation, I know what's going on, I help advise, but it's really, and in this case in particular, even John wasn't that deeply involved because it was a case that was primarily handled by Lauren Kaseberg out of Chicago. And while consulting with us at every stage of the process, there was a little bit of detachment more in this case than the others that were involved in. But part of what I wanted to say was, first, before I get to the specifics of your question, Glenn, is what an extraordinary experience it is to be part of a process where, in this case, we get a call at 3:30 in the afternoon to be in court 10 o'clock the next morning in Chicago, and then at 3 o'clock in the afternoon to walk somebody out of prison who has been there for almost 30 years, going in at age 18, who would have, if the crime had been committed a year later, have been probably given the death penalty, but because he was 17 and he wasn't eligible under the law for the death penalty. And to be able to be there and just be part of walking that person out of prison, you know, to give them a new life of some kind, or at least allow them to continue their life outside of the constraints of being in prison. there's no real way of explaining that to people as to what that feels like. The closest I've been able to come in is the word blessing, not in a necessarily a religious sense, but some of you may want to look at it that way too. It is such a blessing to be part of that. And yet, as I was talking to people over the weekend, many people approaching me, it's a mixture of celebration and feeling tremendous amount of gratitude, but then also sadness. So why is there sadness? Well, certainly there's sadness because in this case, Christopher Abernathy lost the core of his young life in prison. I mean, imagine those of you who have achieved 50 years old, let's say, what it would have been like for you to have had cut out of your life age 18 to age 48 and not have been able to do anything with your life, not to be able to go to school, not to be able to get a job, not to be able to have a girlfriend, get married, have children, or whatever, you know, you would have chosen to do. So there's a bit of a sadness because we know that Chris is innocent. And we know from having worked on the case, I mean, we, you know, to the best that we can, that this young man spent all of those years in prison, you know, which shouldn't have happened. So that's the sort of sad part of it, and, you know, that comes with the elation of both the organizational success in the sense of it validates the work that we do. And unfortunately for people like John, that validation doesn't come often enough. You know, it's so hard to be working on these cases, which take sometimes 6, 8, 10 years to turn around to actually have the person vindicated. And so when they do come, they're cause for tremendous feeling of, yes, this is what we do, this is why we do it.
Mary, I'm going to interrupt you just for a second. We have some questions.
Oh, okay.
Annie, if you're still there, can you press your talk button and go ahead with your question, ma'am?
Okay, thank you. My question is, if you know that the system is flawed, and I'm talking about a small county, where the state's attorney's office and the police are under their jurisdiction and the judges, they're all in, it's a very small community. You go to the television and radio to try and get publicity to it. Where do you go for recourses when you see a blatant corruption? I mean, it's like Gaylord on a way smaller scale. Where do you go for help?
Mary, you want to take that? I will.
Yeah, why don't you go ahead and start, John? You know,
Did you, and I'm just making sure I heard the right term. Annie, was that Gaylord, did you say?
Yes. The judges are so corrupt out here. It's unbelievable.
Well, okay. I guess that the initial answer, which only goes a little bit away, the initial answer is this is why elections are important, and judges are elected, and I know that sometimes good people can be elected, and then when they're in the system then can change them or make them, you know, they become a part of the network, the system that is seen as being corrupt. But this is why elections are important, and this is why good people, good lawyers or others who want to run for any office, but you know, lawyers who run for judges, you know, need help and need backing and need all the things that any other candidate has. So I think that's the first answer. And then, you know, how did Gaylord, you use that term, but how did that ultimately get exposed, if you recall? And I'll rhetorically answer the question. That got exposed because there were some people within the system who ultimately said what's going on is wrong, and so they became cooperative with the FBI and federal prosecutors in terms of exposing the judges, police officers, lawyers, and other people who had engaged in the most incredible level of wrongdoing. And so, it takes someone within the system, if there really is that level of corruption, to be bold. And one more thought, if brave citizens have some remedies as well, whether it's the media, whether it's the Attorney General's office, or other law enforcement beyond the county, there are remedies there as well. But I will tell you that the first reaction of, for example, the Attorney General or a federal prosecutor or whomever is going to be, the very first reaction will very likely be, that people who complain about this are often aggrieved parties and it's just sour grapes. That's their reaction. I'm not saying that that's right, because I understand that perception. But that is very likely to be the reaction. So you really have to have something lined up and ready to be firmed up in order to go forward in any kind of fashion like that.
Let me add a little bit to this. It's a really good question that unfortunately, even though I've studied this for most of my adult life, I don't have a really good answer for you in the sense of, this would solve any particular situation. In most of the cases that we run into, we have not run into systemic corruption in the way you're talking about it. There's sort of a little bit sometimes of collusion, if you will, between prosecutors and judges, but probably the best example I can think of, and you've heard from Randy Steidel previously in this series on the MOOC, it's Randy's case. And there it was systemic corruption. And that corruption went all the way up to the governor's office, through the state police, it epitomized to me the worst of our criminal justice system. I think small counties and small places where there is this kind of, to use your term, corruption, is very difficult to get at. Even though, I certainly would accept my colleague John's statement about elections, we know that it's very hard to swing judicial elections, particularly of people who are already in office. And there's a lot of other things that come to play than just, trying to marshal the votes for somebody in that situation. And so really, my primary reaction is you have to find a way of going outside of the box. If you stay in the box and try to play the game, and that includes to me the elections, in most cases you're not going to go anywhere. So somehow you have to go out of the box. And I think John's comment about particularly making sure that you have the information that can actually result in somebody else acting becomes very important. Just going and talking about rumors or going in about one case or all the things that John was kind of mentioning, I think, are not sufficient. And I think you mentioned in your question that the idea of going to the media, which in fact is a really good way often of exposing these things and also maintaining yourself from being vulnerable, which of course is one of the other problems in doing this, because you're really going up against the power structure. And I would not, having done that myself on numerous times, I would not recommend you do that lightly. In other words, just make sure you understand, and I'm sure that the question sort of implied that. So going to the media is one thing. Going to outside law enforcement agencies is another. But I think that we're struggling in this state right now with the question of how do you break a culture of corruption, either at the statewide level or in your case, talking about small communities. That's not easy to do. It's not impossible, but it's not easy to do. We have been fighting, for example, just to get a pardon for Randy Steidl now for umpteen years, it seems. And we haven't been able to do that. And that's with some pretty big guns coming forth. So I think that it requires staying power. It requires evidence and the ability to convince other people, and either going to the media, going to the Attorney General, depending again on the political connection there, going to the Justice Department, the U.S. Attorney's Office, all of which, by the way, were done in Randy Steidl's case, and we haven't succeeded. So I'm telling you, it's not a simple thing, but it can be done.
There's another student with a very closely related question, or participant, I shouldn't call them students in this. Jacqueline Williams says, I think there's only one African-American state's prosecutor in Illinois, Macomb County, it's not the county, but in Macomb, Ruth Waller. She claims that prosecutors have a lot of leverage in sentencing. Can having more African-Americans in those positions help curtail wrongful convictions?
Well, I was actually involved in a discussion with Ruth just a few weeks ago, and she put the Sangamon County, Illinois state's attorney on the map. It was in a forum, and it was on race relations, and she posed the question to him, well, how many African Americans do you have on your staff? And here he was in a forum talking about how to improve the system in race relations, and he had to sit there and put up his hand to indicate 0. And she then went on and made that argument that it is important. It won't, just as she does not solve the problem in Macon County by any means, it is important to have a diverse group of people in any position of power and discretion. And this is one of those points in the system, and it's a very important one. Prosecutors have incredible amount of discretion and power. We find that out every day because they won't let us even, for example, do simple things like get evidence in a case tested, even though we can pay for it. I mean, and they don't go and ask someone else, can I do this? They have that discretion and power. So yes, you want people in all positions of authority to have that diversity. Again, realizing that doesn't solve the problem, but every once in a while it's going to bring a perspective that, for example, I as a white male growing up in a middle class white society, that I can't bring, even if I want to bring. Sometimes I don't see it in the same way, and that becomes important. So yes, that is a very important part of the process.
Another question?
Sure.
From Sally, when you are acquitted, can they say, when I go get a job where I would work with the disabled, children, or the elderly, that I cannot work with them because of the preponderance of evidence that I am guilty? I was acquitted of AHT, shaken baby syndrome, of the death of an 8-month-old. I was given probation for a year, but that was it. Now I'm still unable to work in the field. In Minnesota, what can I do to get a law passed so that when they perform an autopsy, they have to be board certified? In my case, he was not board certified, and in court was asked if he took his board certification. His reply was yes, but he failed it twice. But yet he was able to say the baby died of a homicide.
There's a lot there.
Yeah.
I'm sorry that you had to go through this experience. First of all, it seems like there's two questions there, actually. And if you could just go through a few sentences of the first one, just a few lines.
So she was acquitted.
Okay.
But she's still not able to get a job working with children or the elderly or the disabled because of a preponderance of evidence that she was guilty, even though she was acquitted.
I guess, and maybe she can supplement the question a little bit, because I'm a little confused about the concept of being acquitted yet serving a year of probation. I'm not sure how that happens. If there's a true acquittal, and I can only comment on what happens in Illinois, if there is a true acquittal in court, that's by the highest level proof that is required in any portion of our legal system beyond a reasonable doubt. If you're acquitted in a court of law, that should do it. And DCFS here then has to acknowledge that acquittal, and they're supposed to wipe their records clean of any kind of indicated findings. The devil's in the details in that. I worked for DCFS for a year, and the devil is big time in the details of getting records wiped out, which are embedded into computer systems. It's very difficult. But I'd be interested just in following up on the concept of probation versus acquittal. It's a little bit unclear to me. As far as the board certification, she
has a follow-up.
Okay.
They say it was preponderance, but there was no evidence that I did anything, so they're just using that statement now.
Okay, and again, if you could address the concept of being on probation, even though being acquitted. I mean, you use the term probation, so I'm just trying to get clarification on that. I mean, probation suggests that there was some kind of finding. So in any event, as to the second question, the rule, it's an interesting and a good one, and here's why. Because the rule of law in every state is that an expert, you don't have to have all of the gold stars pinned on your bulletin board. A person can be an expert by virtue of their training, their experience, and in some areas a person doesn't even have to have a degree or anything like that to serve as an expert in some areas. Now, in this area where we're talking about forensic pathology, I will tell you right now how most judges will react to that. Well, look, if this person is by law permitted to do an autopsy, the law allows them to do this, county hired them to do that, but they're not board certified, your lawyer has a job to do, and his job or her job is to point out to that jury what that means and why that's a big deal. And if the lawyer doesn't do that, then they're not doing their job. And if the judge doesn't allow that kind of cross-examination, then I would say that's a reversible error for an appeal, or potentially reversible error. So, the system is a little stacked. If the county's got a pathologist, there's not too many judges aren't going to let that pathologist hit the stand. I mean, that's just a hard, difficult, and maybe not fair reality of the situation.
She said that the probation was related to her not being a licensed daycare provider, not to the actual shaken baby.
I see. Well, and again, just a sentence or two in follow-up. If that was related to that, I get your question, and I understand. And you may need to sit down, and be a pill to somebody in a good way, and sit down with somebody at DCFS or whatever Minnesota's version of that is, and say, I want proof that this has been expunged from your files, so that I can go back to work.
Another question from Jennifer. This is going back to public policies. Where would the ideal balance be? I understand the public policy. You don't want to require so much evidence for the prosecution that guilty offenders are left to offend again, but the state has such immense power that if the state tells a jury and the press and the public that someone is guilty, odds are that they are going to prison even if there is no evidence. The balance must clearly be in the middle, but how do we get there? And then she's a second part. I saw the amount of fighting it took to get the right to test evidence when the Innocence Project was paying for all of the costs. So is it fair to allow an individual to access DNA testing that wasn't available at the time of their conviction to be so restricted? The ability of an individual who is representing themselves to get the testing is extremely unlikely if the state objects to it, yet the law allows it. Should there be a minimum or a uniform practice across the country to allow at least some access to testing?
Let me just quickly provide a thought or two on the last part, and then let John speak to this. But it may not be the answer that you're looking for, but we're really at the beginning of this scientific revolution involving DNA. I mean, I think we have to remember that. It has not been that long, and what we've been able to achieve to this point is absolutely incredible. And again, talking with people, just that I bump into over the weekend, they say really the world today of assessing criminal justice is very different than it was 20 years ago. And I think they're right about that, and sometimes we lose perspective because, again, we're in our own box that we have to get out of. So my first response would have been, yeah, I mean, anybody who wants to have evidence tested should just be allowed to go and have it tested if they could pay for it, period. You know, it shouldn't make any difference. If that was not available at the time they were in trial, that should be the case. And I think we're going to be there if we're close now, and I think that that's going to happen. It just, it's just not, we're not quite there yet. Because I think we're at as I say, at the beginning of this revolution, which is hard for us to understand because we're the ones always fighting to have this answered. So should somebody who was convicted of a crime and the evidence couldn't have been tested at the time of the crime be automatically be allowed to have it tested, and frankly, I believe even have the state pay for it? I would say yes. I don't think there's any question about that. I don't see what harm it can do. But let me also add that part of the reason I said that we're in the beginning is that, frankly, the laboratories are pretty overwhelmed right now. And that's one of the reasons why we even have to go outside of the state laboratory. We would probably want to anyways. That's a separate question. But the state crime labs all over the country are absolutely overwhelmed because they haven't been able to have the resources to keep up with the new science that is hitting, and therefore the number of tests that they have to do and the sophistication of them. So I think, again, there are some practical, historical factors at work here as to why that just doesn't happen overnight. But I really do believe that as a result of the work the Innocence Movement has been doing and others, that this is not far off to come in terms of having that done. So I don't know if you'd even agree with that, John.
I do, but I'd like to address the first part of the question at this point. The question was about the balance that needs to be struck for there to be just results without setting the bar so high that guilty people escape punishment and so low and so high that that more innocent people are convicted. It's a very difficult question. And lawyers and academics and others struggle with this all the time. But I will say this. I think what we've learned in the Innocence Movement is that, yes, the system definitely needs to be tweaked. There's no question about it. There's some policy concerns, legislative policy concerns that we have strongly on our list that we hope to move forward on. But I think it's fair to say that the vast majority of the wrongful convictions in this country, it's not purely because of the system. It's because of the people in the system. It's because of lawyers who make mistakes, judges who don't care or who make mistakes, police officers, prosecutors, juries, and in a couple cases I know of, bailiffs who do things that they're not supposed to do or who don't do things that they are supposed to do. We've heard from one very highly respected member of the Innocence Movement that they believe there to be a Brady violation, meaning failure to turn evidence over to the defense in virtually every case of acknowledged innocence. That's not a problem in the system. The laws are fine in that area. Give the defense evidence that tends to exonerate. The problem is it's the law in that area and in other areas is not always followed. And so to me, it's the individuals much more than it is the actual system itself.
Well, I would say it's a culture that's created. So it is a systemic problem. It isn't just individuals that are corrupt. It's a culture that allows that to happen.
Sure.
And that's what we have to change. And part of the way to change that culture is information. But another part is what was included in the question, I think, is what responsibility does the federal government have to do some standard, to set some standards? And I think that's something that we could really push for. Certainly the National Academy of Sciences in their reports have called for those kind of standards to be set at the federal level as well as at the state level. And I think that's a really important policy that we want to advocate for, both within the movement, but also to have individuals out there really calling for that. Because these kinds of mistakes that you're talking about, or the corruption of individuals, is allowed and not reported, and as pervasive as it is because of the culture in the system right now. And that's what we really need to change.
Yeah, I was going to say exactly that and part of that culture, by the way, I believe has been, at least over the last number of years, that despite the theoretical presumption of innocence when people go to trial for crimes, I believe actually that it's really, you're presumed guilty because most juries and I suspect even judges believe that prosecutors and police, when they come into the court, they bring in the cases that they think the person is guilty, and they buy into that until someone demonstrates that's not the case. Now, I don't have empirical evidence about this, but I think I think except for the fact that we know the extent to which people get convicted and are either innocent or are convicted and given crimes, given sentences that are disproportionate probably to what they should have had. And also, the one thing that we haven't mentioned is that in criminal cases, in 95% of all criminal cases, there are plea agreements. And I'm absolutely convinced that that a significant number of those plea agreements are people who are either innocent or have not committed the crime to the extent that they end up having to serve the time in prison. So again, I think Gwen is right, that it's a mixture of culture and systemic causes here, that in fact the culture, it becomes absorbed as part of systemic behavior.
We have one, Diane has a question, if you guys have time to take one more. Okay, go ahead, Diane.
Yes, thanks. Despite the high wrongful conviction rate in a large population, it seems like Illinois has very limited resources to challenge convictions without DNA or forensic evidence, especially out of Cook County, and then also to work on prisoner issues. I think I can only know of one or two projects in the state that will even touch prisoner issues, yet there are plenty of new attorneys coming out of law school who can't find work right now. Can't something greater be done within the legal community to pair law students with large firms and encourage these firms statewide to do more work pro bono? Online resources for individuals, for instance, they provide guidance for civil work or for legal aid, but not for criminal. Our state prisons are overcrowded and the state has no money, so conditions in them are only going to worsen. Is there any relief on the horizon for getting more pro bono resources for non-DNA cases and non-forensic cases, and to work to prevent convictions in those cases?
And just a question of clarification, are you referring to so-called prisoner issues in terms of how, their standards of incarceration and that sort of thing, or are you talking about working on their cases in an attempt to
I'm talking about
demonstrate
prisoner rights within IDOC, for instance, because conditions in there are just horrible.
Sure, they sure are, yeah. Well, I do know of at least one law school that has a prisoners' rights project. The law school in Champaign does, and I think it's a great suggestion. A lot of you mentioned law firms. A lot of law firms. I'm a lawyer, but I'll be real honest about it. A lot of law firms don't want to touch it because it's not what they do, and so some just don't want to go there with prisoners' rights issues. I think the law schools and the certain law firms it's a wonderful goal, and things only happen when somebody steps up and organizes it. So a great suggestion, and if you have a particular inmate, prisoner that you're concerned about, you might write to the project, Prisoners' Rights Project at the law school in Champaign.
There's also an organization called the John Howard Society that that works on prisoner reform. But again, you touched on a piece of the puzzle that is, again, I believe, part of the systemic problem of dealing with criminality in our society. And frankly, most of the people in this country, I believe, don't care about what we do with prisoners. They're out of sight, out of mind, and that's the way they want it. And it makes it very, very difficult to deal with these kinds of issues. The kinds of things that are happening in our prisons. For example, I heard that even our own new governor, who went and visited prison last week, was horrified at what he saw. He'd never been in a prison before. And, you know, and I just, I think it's very, very difficult to get at those things. And one of the reasons why, and I think you'll all be sympathetic with this virtually wherever you're living in the United States right now, is our unwillingness to put resources into this problem. And I know it's easy to say resources don't always solve the problems, but this is one of those issues where resources, and it's going to require a lot of resources if you want the kind of change that you're talking about in terms of making prisons a place where, not necessarily as sometimes is portrayed as country clubs, but certainly as humane places where the people who get out feel like that they have some respect as human beings. And let me give you just a brief example of how bad that can be. One of our exonerees, and this goes back to the original question where we started with the Gwen had asked, one of our exonerees who got out of prison 2.5 years ago, had spent 14 years of the core of his life in prison on a life sentence for a murder he did not commit. And he's very bright, very articulate, and I'm convinced, I mean, at one time one of his goals was to go to law school and become a lawyer. And when he got out of prison, I looked at him one day and I asked him, I said, you know, did you get any education, you know, maybe, you know, even a junior college degree or something in prison? And he looked at me and said, are you kidding? They don't provide any education for people who are given life sentences because they assume that we're never getting out of prison, and so why should they invest anything in us? So, you know, the issue goes all the way from physical conditions to the bigger question of what is it we're doing when we put people in prison, and how should they be treated psychologically, educationally, emotionally, and physically. And that's going to require a lot of resources to change that. And then that goes back again to John's point about the importance of people being good citizens and pushing for these changes to occur.
Yeah. Well, thank you all so much for participating, both John and Larry and all of you out there, and John Loevy from earlier. And I want to tell you that we are going to have another live session next week. It's going to be in the evening on Monday night, March 2nd. And we're going to be talking with Jarrett Adams, who is an exoneree and also a third-year law student now at Loyola, and one of the founders of Life After Justice, which is a program that he started with Antoine Day, who you've seen in the videos, to help people once they've been exonerated from prison. And that's a really important issue that we're going to take up in week 5. So thank you so much, and hopefully we'll talk to you next week.